Okay, good afternoon, everyone. Welcome to Collier County Court. I'm Judge Martin. We have a matter set for 11:30 for a pretrial conference in anticipation of a non-jury trial. The case is styled first title versus Ula and Breen, although at this point it is basically Ula versus Breen. I don't know if I'm pronouncing that correctly. How do you pronounce your last name, ma'am?
Eula is correct.
Okay, Eula. All right, and all right, so I have Ms. Eula. And Ms. Eula, are you still representing yourself, or have you got an attorney?
I'm representing myself.
All right, and let me figure out who my other two folks are here then. If you want to unmute and state your appearance, Mr. Mundy, what's your role in the case?
Yes, I represented the plaintiff, and there was an order dismissing the plaintiff with prejudice, and I just wanted to make an appearance on the record to see if the court required anything of us.
I don't believe so, Mr. Mundy. I think this is just the back half of the interpleader. So yeah, I think I can let you drop off if you'd like. I'm glad you didn't have to travel far.
Of course. Thank you very much, Your Honor.
All right, thank you. And then it looks like Mr. O'Brien.
Yes, Your Honor. Christopher O'Brien on behalf of defendants Jessica L. Breen and William H. Breen. They're also cross-claimants in this matter.
Okay, and that's Mr. O'Brien with an E. Got it.
Yes.
I'm doing my own minutes here, so I will make those notes. Okay, so Ms. Eula has filed a few different times requesting that the court give her a judgment, and if not, set this for trial. And certainly I can set this for trial. So today is the pretrial conference, and I had done an order that required both sides to take certain actions. And I've got the plaintiff's pretrial compliance. I'm sorry, I've got the Breen's pretrial compliance and Ms. Eula's pretrial compliance, both dated January 22nd. So my purpose today then is just to basically figure out when we can get this set and resolved for you all. Mr. O'Brien, I'm going to turn to you first as counsel. Is there any other legwork, discovery, anything else that you all need to do before you'll be ready for trial?
Yes, Your Honor. The first thing is this case isn't currently at issue. We had filed a cross-claim back in July 8th of 2019. Attached, at June 25th, 2019, with our answer and affirmative defenses. Defendant's counsel filed a motion to dismiss the cross-claim. There was never a motion heard on that, and then subsequently the counsel withdrew. So we still have that pending motion to dismiss, and then, depending on Your Honor's order on that motion to dismiss, we would most likely require an answer to our cross-claim.
Okay. Okay, and then we would be procedurally prepared for trial.
And Your Honor, I would like to propound some discovery as well.
Okay, well, you could have been doing that all along, right?
Oh, yes, Your Honor. So the issue is that the reason why this case is kind of stalled is that back in, back in November 12th, 2019, counsel for defendant Ula filed a motion to withdraw that didn't have Ula's signature on it. The case was pretty much stagnant. I was waiting for her counsel to set it for a hearing or to work out their differences. It came to a point where I believe Ms. Ula started filing pro se filings while still represented. I contact with her counsel, and I demanded he set it for a hearing. And I demanded him to figure out the issue. He was under the impression that he could just file the motion and be done with it.
Yeah, no.
So he eventually did get defendant Ula to sign off on a stipulation, and it was set for a hearing. And then here, I will admit that here comes, I'm at fault as well for having this being stagnant. There was an order giving defendant Ula, I believe it was probably 30 days to get new counsel. I initially let the 30 days, and I decided I would wait to see if defendant Ula would get counsel before I attempted to contact her directly or get discovery or set hearings.
Right.
Honestly, Your Honor, it kind of just fell off my radar. I know you've been probably hearing these excuses all year, but I was working from home and handling other matters, and it wasn't until Ms. Ula again was filing, which she's allowed to file her pro se filings, that
Right.
came on my radar, and then preparing for this pretrial conference, I realized, oh wow, this case isn't even at issue. We still have this motion to dismiss hanging out there.
Okay. Well, it doesn't look terribly complicated. Give me an idea of what sort of discovery you need to do. I mean, aren't we just interpreting a line in a contract as to whether or not it was complied with?
Yes, Your Honor. We have reason to believe that defendant Ula did not engage in a good faith attempt to obtain financing, either through her disclosures to her proposed lender or her attempts to achieve other financing. So we're going to be asking for her copies of applications and communications as well, and information about her income and her employment during that time period when she was applying.
All right. And attorney's fees are in play under this contract, is that right?
That is correct.
So, and this is for both sides' benefit, Ms. Ula, the winner's going to pay the loser's attorney's fees. So if you're right, ma'am, there's no reason for you not to have an attorney, because ultimately they're going to have to pay for the attorney. If you've interviewed attorneys and they all tell you, this isn't a good case, we don't want to get involved, please proceed with caution, because that might be good advice, and you're going to end up paying for their attorney. The longer this goes, the more expensive that gets. In other words, it's a suit about a whole lot more than $10,000. And I just want to make sure, at the moment, I don't have a clue who holds the upper hand or who holds the high cards here, but I'm always worried that people might be trying basically to save money by not getting an attorney. But if the attorney is going to be paid for upon victory, essentially, then I just want to make sure you're aware of that, and that that's something you consider in case, typically speaking, a good attorney will pay for himself or herself. A bad attorney, different deal. But you had counsel, and counsel dropped off the case. I just want to make sure that you're aware of your right to replace that counsel and the benefits that you may enjoy from replacing that counsel and having an attorney. Is that something that you had considered, Ms. Ula?
Yes, Your Honor. As I explained to you the last time when we spoke, that I've dumped a lot of money into this, like $6,000 already into it. No counsel is going to represent me for free. I know that. And it's as simple as a contract. And as you can see, it's an easy case. The opposing party has dragged their feet because their money's not tied in it. So they don't have to pay for counsel. I do. So
They are paying for counsel, I suspect.
I don't know. All I know is that it's easy as just reading the contract. The discovery that they're talking about, I mean, it's already there. Everything has been provided to them. There's really nothing more to look into. And that's all the documents that I have to provide them.
Okay, and that's fine. With regard to the attorney, it's interesting. These cases do come up a lot. I actually just finished one similar to this, although there was not a financing contingency. But the attorney who represented the person in your position had a fee agreement where they quoted a relatively low fee of $2,000, but then it was contingency beyond that. In other words, if they won, then they would be able to recover their time. And the time ended up being, probably $20,000. But they did a fee contract that I thought was interesting and that has been upheld by the courts in order to take people in your situation and give them an opportunity to get counsel without spending $20,000 up front. if they really do have a valid claim. So I just want to let you know that's out there. I hope you've considered it or explored it. If you're correct, and you may win without getting a lawyer, that's very, very possible. It's just a whole lot harder for you. Your time also has value, and you're going to spend a lot of time. Potentially, an attorney may be able to get you where you want to go faster, and time is money. But you don't have to have an attorney, and it is entirely possible that you will be able to prevail without one. I just need to kind of go through and make sure you understand there's some risk, but also some reward either way you go. If you choose to continue to represent yourself, that's fine. If they wish to go through discovery, they can do that under the rules. I can certainly set a very short time limit on that, and we do need to. He's right. Your attorney never tied up the loose end, and neither has the other side. And I think you're probably also right that their money isn't sitting in an account right now. Yours is. Now, they may claim it, but they didn't come out of pocket to put it there. And I understand that. But both sides right now are bound by the rules. The rules allow things to go forward a certain way, and I have to follow those rules. So it sounds like what we need to do is a few things. It sounds like we need to schedule the motion to dismiss to be heard. We need to set a timeline for discovery to be completed. And the last thing that is running through my mind is the possibility that we have the case set for a mediation. I don't know if that has been done. One thought that I have is the court mediator is very low cost, and off the top of my head, I believe this case would qualify for the low cost mediator. I can appreciate, Ms. Ula, that you may not want to hear any of that, because to you, it's crystal clear that they have your money and you want it back yesterday, and you don't want to do a mediator, you don't want to do discovery, you don't care about the motion to dismiss or any of those things. Here's the problem. I don't know if it's crystal clear, and I don't know if you're right in your own thinking that it is crystal clear. They've at least invested, I'm going to guess, several $1,000s so far to have an attorney try to fight for this several $1,000s. In our world, this is a small sum, and they may have already paid more for the lawyers. Certainly between both of you, you have probably paid more for your lawyers than was at controversy here. I see that all the time. That's not unusual. Because both sides feel they're right, and they're confident that the other guy is going to have to pay for their lawyer anyway. So lawyer, have a big time, run it up, do whatever you need to do to fight this fight, because we think we're right and we're going to win. That's the scenario you're in. And so again, I reference, you may be at a disadvantage to try to fight this fight without a lawyer, because again, I don't know who's right here. It is often about 5 minutes of a trial that actually brings the whole thing to a head and gives me the opportunity to see who was right. But we're not there yet. And there's a fair amount of procedure that has to be conducted before we get there. So I'd like to craft a timeline here. We can set that motion to dismiss before we hang up now. And I'll get that heard. I could get that heard before the end of the month. I don't think there's any reason you can't conduct your discovery at the same time, Mr. O'Brien. And Ms. Ula, the rules allow you to conduct discovery as well, to make requests for them to admit things, to give up documents, to answer questions under oath. Those are all, procedures equally available to both sides. But I'd like to set a timeline on that, and then probably I'm going to have us touch base quickly and follow that up with a trial. The trial could happen in a relatively short period of time from here, because really there's no reason for this to have gone on this long. It's a little bit unfortunate. Part of it probably rests with prior counsel. Part of it rests with current counsel for the Breens, but we're going to fix it now. So let's look at our calendars and let's get the motion to dismiss set. And while I'm doing that, Mr. O'Brien, how long is it going to take you to get the discovery sent over to Missoula?
I can have that discovery sent out probably before the end of the week, Your Honor, the request for documents and interrogatories.
Okay. And then that's going to give her 30 days under the rule to get that back to you, right?
Correct.
Okay. All right. And I don't think any discovery from either side has any bearing on the motion to dismiss, so we can set that anytime, right?
I agree, Your Honor.
Let me just look at a couple of dates. We've been pretty slammed lately, but let's see what we can get set up. Okay, why don't we look at Monday, February 22nd? What sort of time do you believe we need, Mr. O'Brien, for that motion?
I think 10 to 15 minutes at the most. I believe it's a very simple motion. I don't think there's going to be a need for a lot of discussion.
Okay. Would February 22nd at 11:30 work? It would be a Zoom hearing like this.
Your Honor, I'm available the 22nd at 11:30.
Ms. Ula, would that work for you?
Can we do it like later in the day, if possible?
We can do that. And let me ask a dumb question, Ms. Ula. Your prior attorney filed this motion and that attorney is no longer on the case and you've not replaced him. Do you wish to persist with the motion to dismiss, or do you want to withdraw that and agree to simply file an answer so we can skip that step? I'm not pushing you in either direction, but before I set a hearing, I want to make sure you still want to push that particular motion.
I don't even understand what exactly that is about.
Okay. Well, again, this is why I talk about lawyers. I can't give you advice. I can't even really tell you what that motion is about. I'm happy to schedule it for hearing. I have, under the rules, I have to treat you the same way I treat Mr. O'Brien. The rules are equally available to both sides. And if you choose not to have a lawyer, then everybody operates under the same rules. I can't stand in as your counsel because you don't have counsel. But I do want to just note that that motion is something under which you have control. If you want to keep it and have me consider it, we can schedule that now. And I can absolutely give you an afternoon time for that day. But if you don't wish to persist with the motion, you have the power to withdraw it, and then you would simply need to, as Mr. O'Brien said, file an answer to the original complaint. And I can't tell you what to do or the pros and cons of any of that. And you don't have to answer my question. We can set the hearing now, and you can, between now and that hearing date, consider the question, consult an attorney, if it turns out that between now and then you want to withdraw the motion, you can simply file notice that that's your intention, that you're withdrawing the motion, and that you're agreeing to just answer their cross-claim.
That's
Are you
fine.
following what I'm saying?
Yeah, that's fine, Your Honor. We can just go ahead and set the date later in the evening that day. I'll do more research exactly what that was, and then we can just move from there.
Okay. What I would have available as an alternative, if we stay with February 22nd, I could do 3:30 in the afternoon. Is that better for you, Ms. Ula?
Yes, Your Honor, that's perfect.
Mr. O'Brien, does that work okay for you?
Yeah, that works.
Okay, so 2/22 at 3:30 on the motion to dismiss. And I have emails for both of you, which is great. So Ms. Ula, that's one advantage, at least because we have your email, you're getting immediate notice of everything. I'll do both sides the favor of doing the notice of hearing for that, since it's really Ms. Ula's motion and she's pro se. We typically do the notice for pro se folks. So we'll do a notice that sets that defendant motion to dismiss for February 22nd. That's a Monday at 3:30 p.m. And we'll set that for 15 minutes. And again, Ms. Ula, if you get counsel, obviously be sure that they're aware that we do have that hearing coming up and that they should touch base with Mr. O'Brien. If you decide you don't care to persist in the motion, just notify us. Hopefully not at the last second, but at least a day or two in advance so that Mr. O'Brien and I don't invest a lot of time preparing that. That will be the motion to dismiss. If I grant that motion to dismiss, then Ms. Ula does not have to file an answer, and the pleadings will be closed and ready to go. Do you agree, Mr. O'Brien?
Yes, Your Honor. I don't see how this case can proceed without a cross claim if it's an interpleader action.
Well, and you may be right about that. I don't know. I did read the file and I did read the motion, which cited some legal authority that supposedly stood for the proposition that on interpleader, you don't have to do that. You simply answer the main claim, and then the two of you are in the ring to duke it out.
Mhm.
I suspect that might be good authority, but I haven't really looked at it. I haven't drilled down. I simply read the motion and saw the motion there. I have certainly had these cases without cross claims, but
Okay.
for all I know, the folks were doing it incorrectly. So you might want to take a look at the authority that I think it was Mr. Silverfield at the
Yeah.
time.
I've checked it, and I'm already prepared for the motion to dismiss.
Okay. I have not looked past the four corners, but I glanced at it, saw that there was some authority cited, glanced at if I'm not mixing up my files here, that you all had perhaps a response. Let's see.
I don't believe, Your Honor. I don't believe we responded to the motion.
Okay. I've read a lot of files today, so yeah, I see the answering cross claim, their motion to dismiss, plaintiff's motion to interplead, and the order that grants that. And I would have to, do research, as Ms. Ula just said. I'd have to do some research to see whether the motion to dismiss is well taken. Again, I think if it is well taken, then the cross claim's dismissed. The pleadings are closed because both sides did answer the original complaint from the plaintiff, and then we could set our trial.
Okay.
But if the motion to dismiss is not well taken, then I would deny it. I would order Ms. Ula to answer your cross claim, and once she answers, we would be in a position to have our trial. That's my synopsis of where I think we are personally. Mr. O'Brien, do you differ with those two possible pathways based on the motion to dismiss?
I agree with Your Honor.
All right. And so we'll be doing discovery in the meantime. Discovery would still be outstanding when we have our February 22nd motion to dismiss. I'm going to go ahead right now and set one more date. I think what I'm going to do is continue today's pretrial conference to a date in March after the 30 days are up for the discovery, and see where we are then and potentially set a trial then. So if you propound discovery this week, which I'm going to require you to do based on the delay, I think we need to tighten this up, then we would be safe to, let's see here. Let's do a pre-trial conference. Ms. Ula, is afternoon better for you always?
Yes, Your Honor.
Okay. I'm looking at Monday, March 8th. And if you propound discovery timely and Ms. Ula answers it timely, and I'm confident that she's going to, I know she's motivated and competent. So Monday the 8th, we should have that discovery closed. And then I could set you all for a trial following that. So I might look at Monday the 8th. I do that same 3:30 time, since that seemed to work for Ms. Ula earlier. Does that work for you, Mr. O'Brien?
Yes, that works, Your Honor.
Monday. Does it work for you, Ms. Ula?
Yes, Your Honor.
All right. And I think last question for what I can do today, Mr. O'Brien, do you have a sense as to, I think everybody seems to agree we're in a non-jury trial posture, which is good because jury trials for county civil are probably not going to happen for a while with the pandemic. But we've been having very good luck with non-jury trials on things like this. I don't think this is going to be, 20 witnesses or a lot of physical evidence. It's probably all documents for evidence and individuals testifying, and it sounds like just a few individuals. So, Mr. O'Brien, do you have a sense as to how long you would expect a non-jury trial to require in this case?
Your Honor, I believe a day or half a day. I don't think there's going to be a lot.
Okay. And I had sketched out, I think, in my notice to you all that I expected it probably to be a half day. Ms. Ula, do you have a sense of anything different from what I've just suggested as an overview? Do you think this is likewise relatively simple, straightforward, not a whole lot of documents or witnesses?
Yes, Your Honor.
All right. So let's continue to anticipate it's a half a day. My guess is I'm going to have Ms. Ula and probably one of the Breens. I may or may not have either side's realtor. I may or may not have either side's, or Ms. Ula's, I guess, maybe a mortgage person that you want to have be a witness, Ms. Ula. But I understand the question seems to be whether you complied with a contractual obligation, and I'm going to use the wrong language probably, but to make all reasonable efforts to secure financing on time. So that sounds like a half a day. Since we won't have a jury, we'll hit the ground running when we start at 9 a.m. And we'll fix a date for that when I see you all the afternoon of March 8th. And if between now and then that changes or something's opened up based on the discovery that we think we're going to need a full day, we can talk about that on the 8th. That's fine. And likewise, if Ms. Ula does opt to have counsel, obviously, Ms. Ula, the sooner you put somebody on board, the more value you'll get for their involvement, because I know you want this to move quickly. And don't bring a lawyer in the day before the hearing. You're going to probably end up costing yourself a delay, and I know you don't want one. And again, if you stay pro se, that's absolutely fine. I just want to do my part to make sure you kind of know the lay of the land and you understand that I will be restricted from being able to offer any more to you than I offer to Mr. Bryan in terms of just making sure people understand but are not receiving assistance. Okay, so I will do an order that essentially is a case management order, and I'll in that order I will note that we're going to continue the pretrial conference, but that plaintiff will propound discovery, and you can serve that by email, but it'll be no later than close of business on the 5th. Can you do that?
Yes, Your Honor. Should be no.
And again, Ms. Ula, if you wish to propound any discovery, I'm not putting the same timeline on you, but if you do wish to do so, you're welcome to do so. The rules are relatively plain spoken on how to do that. If you want to keep the tight timeline that I'm trying to assist you in setting, then try to kick that over to Mr. O'Brien on the same timeline. And then the rules permit a person receiving that discovery 30 days in which to serve their responses. And And then that'll give us a meaningful pretrial conference on March 8th. We'll be on the other side of the motion to dismiss, the other side of the discovery, and we should have our cards pretty well on the table, and I can set a trial from there. I'm retreating probably from the idea of mediation unless something were to change. Let's let you all do the discovery and the motion to dismiss. And then we'll see whether the time is better just spent going to trial or whether we think there's something fruitful for a mediation. So I'll table that idea until I talk to you all on March 8th. All right, anything else I can address for the Breens, Mr. O'Brien?
No, Your Honor, thank you.
Anything else I can address or clarify for you, Ms. Zula?
Your Honor, I had a question about the discovery.
Okay.
So they have a certain time to ask for whatever they ask, and then I have a certain time to respond to it, and that's the end of that, right?
Well, the rules permit a certain amount of discovery. So I imagine I have had, to answer your question, I've had cases where there's multiple rounds of it. In this case, I don't expect that's likely. Again, both sides, I think, agree that this is a pretty narrow issue. So I'm asking Mr. O'Brien to try to put out there what he needs to try this case and to do that this week. So I can't predict the possibility that some new issue arises based on what your answers are, but more than likely, I'm anticipating there's one round of discovery here. These are cases that are fairly common and not terribly, usually not a lot of curveballs. Does that answer your question?
Yes, but the other thing that I had a question on was, like, for discovery, the things that they asked me to disclose, you know, like I anticipate that they're going to ask me for things that, what if I can provide them, or what if that is not pertain to this case?
Yeah, and that gets back to the legal advice. And unfortunately, even if I know the answer to that question, I'm not permitted to answer that, because then I am giving you legal advice on how to handle your case. So this is where I come back to, just after an awful lot of years of experience, if you're right and you've got a contract that's going to get your lawyer's fees paid, there's really usually not a downside to having an attorney. And you should think about, there's a lawyer referral service through the Collier County Bar Association. I don't know if you would qualify for legal aid. If you're looking at buying a $200,000 house, you might not. But think about legal referral as a source, and think about trying to interview a couple different lawyers. Again, there are some fee structures out there in the legal market that contemplate this type of a situation where somebody's not going to fork over 20 grand up front to fight over 10 grand. But there is, you know, again, if you're right, if the lawyer looks at your case and says, you've got a great claim here, they may be willing to take a small amount up front and run the risk that they hopefully will be able to recover what's called a contingency at the end. So you've got to be an active person in the market. You obviously were in the market once, you had an attorney. I don't know and don't need to know what caused that relationship to end, but you have already obviously invested some money. I just encourage you to think about trying to consult an attorney. Sometimes an attorney will take, you know, an hour, 1 hour fee to at least just instruct you on the answers to those questions, but they won't actually jump in the case. That's another thing that the legal market sometimes might offer you. So you can explore it. You can put whatever time you want to into it, but under no circumstances am I going to be able to answer those sorts of questions. I think I'm inbounds to let you know there's some resources out there that you should consult, but to actually answer the substantive question, I can't do. Do you have anything else that I can clarify or suggest with regard to where we are and what you might do about it in terms of accessing some resources?
No, Your Honor.
Okay, all right. I can appreciate that it's confusing and frustrating and not a lot of fun to be in a field that's not your, I don't know what you do for a living, but that's not your normal field. But there are rules, and you can review them and you'll know what I'm going to be working with. But I have to, if you don't have counsel, I have to treat you the same as I treat the other side's lawyer. So we'll be operating under those rules. With that, I'll let you all go, and I'll take care of the notice of hearing on the motion to dismiss, and basically what will be a case management order that sets forth what we have to look forward to coming from here. Okay? All right. Good luck to both sides. Stay well, everyone. That'll conclude our morning session.
Thank you, Your Honor.
Thank you.